On March 31st, New York State legalized the recreational use of marijuana. And the next day, New Mexico did the same thing. Those states joined over a dozen other states that previously had legalized the recreational use of marijuana, and 3 dozen states that had legalized the medical use of marijuana. So things are now moving so quickly that a lot of financial institutions and marijuana-related businesses that are seeking financial services have lost track of where things stand. So today I'm going to talk a little bit about what the legal landscape is for providing financial services to marijuana-related businesses, what some proposals are that are likely to be considered by Congress this year, and finally, what financial institutions can do now to prepare for these proposals being passed in the future. The starting point for understanding the current legal landscape is that the manufacture, distribution, and sale of marijuana is still illegal under the Federal Controlled Substances Act. What that means is that if you do business with a marijuana company, you're at risk of either being charged with the crime of conspiring to violate the federal narcotics law or aiding and abetting the violation of the federal narcotics law, or separately, you could be charged with either conspiring to violate or actually directly violating a money laundering law, which includes engaging in a transaction with proceeds of a sale of marijuana. It appears likely that President Biden is going to deprioritize the prosecution of marijuana-related crimes. This had been done previously under the Obama administration in something known as the Cole Memoranda. But nevertheless, there are a number of non-criminal charges that theoretically could be brought, including violations of asset forfeiture law that could result in the forfeiture of property, or civil money laundering charges. And in addition, regulated entities should be concerned about the possibility of losing their licenses or potentially losing their charters if they engage in a transaction that is deemed to be a violation of federal law. It's been widely recognized that the current regulatory scheme is counterproductive. It doesn't make sense to allow marijuana-related businesses to operate and at the same time to deny them the ability to engage in financial transactions through regulated financial institutions, because this forces these companies to engage in transactions through unregulated institutions or to engage in all-cash transactions. So because legislators have recognized that the way things are set up right now just doesn't make sense, they've proposed a couple of reforms. One is the Secure and Fair Enforcement Banking Act, or the SAFE Act. There's always a clever acronym. And that is targeted at protecting financial institutions and employees of financial institutions. And the second is the Marijuana Opportunity Reinvestment and Expungement Act, or the MORE Act. And that is a much more broad piece of legislation that is intended to decriminalize marijuana generally, and as opposed to focusing specifically on financial services. Given that both of these proposals could have a significant impact both on the industry and on financial institutions, I'm going to discuss each of them in turn. The Safe Banking Act was actually passed in the U.S. House of Representatives back in 2019, but it never was passed in the Senate. And this year it was reproposed on March 18th. The Safe Banking Act proposes a number of protections. First of all, it directs financial institutions, regulators, not to discourage financial institutions or prohibit financial institutions for processing transactions for legitimate marijuana-related businesses. It also protects the financial institutions themselves from forfeiture, from civil prosecution or criminal prosecution solely for providing financial services to legitimate marijuana-related businesses. And it also provides protections for employees, protecting them from prosecution simply for providing financial services to marijuana-related businesses. Finally, it provides some protections to third parties, not just financial institutions that engage in financial transactions with marijuana-related businesses. the Safe Banking Act would not actually decriminalize the sale of marijuana at the federal level. So that means it would leave in place a certain tension between it being a crime to sell marijuana and it being permitted to provide financial services to companies that sell marijuana. In contrast, the MORE Act would directly address that problem. It would decriminalize the sale of marijuana at the federal level when that sale is done by legitimate state-regulated marijuana businesses. And that would have a sweeping impact on the ability of marijuana-related businesses to do business. And it would also have an immediate impact on the ability of financial institutions to provide financial services to those companies. In addition, the MORE Act seeks to address some historical impacts of marijuana having been against the law in the past. That includes expunging the records of certain past convictions, and it also includes certain prohibitions on federal programs for discriminating against individuals who have a prior conviction for marijuana sale, marijuana possession, or marijuana distribution. In December of 2020, the MORE Act was passed again by the House of Representatives, but it has not been passed by the Senate. Given that the proposed marijuana reform legislation that we've discussed today hasn't yet been enacted into law, what can banks do now to get ready? Well, first of all, don't wait until the law is passed to start developing your internal policies and procedures. This is a massive opportunity. It's a huge financial opportunity for financial institutions, and this means that first movers are going to have a big advantage. So you want to start getting ready now so that you can hit the ground running if and when it becomes possible to offer financial services to marijuana-related businesses. Second, you want to make sure that your internal systems will be able to implement a state-by-state policy. And that's the case because even if the proposed federal legislation is passed, it would not eliminate the prohibitions at the state level on the sale or distribution of marijuana. So you want to make sure that you would not provide financial services in a state where that is still a crime. Third, you want to develop a plan for marketing. And this means both a plan for marketing after it becomes legal to provide these services and possibly even outreach at this time to institutions that you think might seek your services if and when the legislation is passed. Finally, you want to have a game plan for dealing with regulators. If this becomes legal and permitted at the federal level, it will immediately be the case that regulators are going to have a lot of questions. And you want to be ready with answers. You want to be ready with answers on how your policies are going to be implemented, how your procedures are going to be implemented, how transaction monitoring will work, what your staffing levels are going to be. And if you have all those answers, you're going to get approval or non-objection a lot faster. So this is a complicated area. The opportunities are tremendous. The potential penalties are large. But good news, I'm a lawyer. So if you have questions and you want to discuss what it means to provide financial services to marijuana-related businesses, give me a call. I'd be happy to talk it through with you.